In this episode of the BoormanLawyers Court Reports show, we take a look at a high-range drink driving offender on his third drink driving offence at the Downing Centre Local Court in the Sydney CBD.
Yeah. Honestly, I think that 24/7 an understatement to my day-to-day. If ain't no way, then I'ma make a way. They say it ain't no way. I ain't never listened, kept them at a distance. This is for the ones who ain't afraid. And this is more than a paper chase. I wonder who else could say the same.
G'day, it's Josh Boorman here from BoormanLawyers. I just want to come to you today with a new court report update. I've just attended the Downing Centre in the Sydney CBD. This is Australia's busiest local or magistrates court in Australia. I appeared today on a high-range drink driving offence, and what made this matter far more serious was the fact that it was my client's third drink driving offence. Now, it was the first DUI within the last 5 years, but 5 and 6 years ago he had a low and a middle range drink driving offence as well as on top of that a disqualified driving offence. So he did have a very poor record, and for that reason the magistrate ordered that he go along and perform a pre-sentence report or a duty report, which basically was an independent report conducted by probation and parole to assess whether he was suitable to complete any sort of level of community service as a way of punishment. But whilst we got that, we got a lot of preparation together. We got our client along to see a psychologist. We got a very strong psychological report put together. We got him to complete the traffic offenders program. We got a good reference from his ex-wife and a good letter of apology, along with some other material just to show how he's been going through some financial difficulties of late. But the big things that we were able to push across to the court was, which they previously weren't aware of until we got presented our case today, was the fact that our client has just been going through a messy divorce. He's just lost his job. He's been financially struggling, and unfortunately on the night of the offence he made a very poor decision to drink alcohol in excess as a way of coping with his issues that he's been dealing with, and then make the very poor decision, which was obviously a decision which was affected by his level of intoxication and his emotional state at the time, to then get into his vehicle and drive. So it was a serious matter, but we did a lot of preparation for this case. We adjourned it, we got him in to see the psych, we got him to do the traffic offender program, we got some good references, some good material to tend before the court, some good persuasive arguments to show that whilst he has had these issues in his life, he is now addressing them and moving forward in a positive light. And the main thing was that it's very unlikely that he will now come back before the court, since he has remained abstinent from alcohol for several months. And if he can continue on with this treatment that he's getting with his psychologist to remain abstinent and have alcohol out of his life, then, as I presented to the court, it would be very unlikely that he would appear back before the court again in the future, despite his history. So our submissions were well received by the magistrate, despite him having a pre-sentence report saying that he was suitable, willing and able to do community service, and that was an available option. The magistrate did look at the steps that he's taken since the incident occurred, the material before the court. He heard my submissions and he decided to step it down a level and just put our client on a good behaviour bond for a period of 18 months. In addition to that, he got a 7-month licence disqualification. He couldn't escape the mandatory interlock provisions of having an alcohol interlock device in his car for a period of 2 years after he got his licence back. But basically that's a mandatory law that has come in, and but we were able to avoid him doing any community service orders or time under a community service order. Instead, we reduced his penalties down to a good behaviour bond. We were able to get the magistrate to backdate his disqualification to the date of the offence, so he'll be able to get back on the road with an interlock device in and around August. But he certainly was extremely worried that he could be looking at some sort of term of imprisonment But the way we handled the case, we put a strategic plan to try and minimise his situation, show the court he was addressing his issues, and this was certainly very well received by the magistrate, and he could see that he was now doing something about treating the root cause of his offending behaviour. So guys, if you've found yourself involved in a drink or drug driving offence in and around Sydney, New South Wales, then rest assured we attend all courts around Sydney, outside the famous Downing Centre local court today, busiest court in Australia, and we got a good result. So feel free to give me a call on 1300 941 900 if you have any questions or issues surrounding your situation, or alternatively go along to our website, which is BoormanLawyers.com.au. That's BOORMAN lawyers.com.au. Thanks for tuning in today, guys.